There are some formalities with regard to residential leases that we need to understand. The first formality is that all leases require registration. Residential leases are regarded as leases with a term in excess of 21 years. Any lease with a term in excess of 7 years, or where there are 7 years remaining on the term, needs to be registered at the Land Registry. That's courtesy of the Land Registration Act 2002. There's no requirement that the lease is registered with an absolute title, simply a requirement that the lease is registered. In addition to that, in any new lease that you're creating or a landlord is creating, it is necessary that the lease is in prescribed clause lease format. These are standardized front sheets prescribed by the Land Registry, in which the landlord who drafts the lease includes all the key information and data that the Land Registry and HMRC need. The idea of prescribed clauses is so that the Land Registry or HMRC do not need to trawl through the lease, which can be a complex, multi-page document in which it can be quite difficult to extract information. Most residential leases vary from developer to developer, can vary over time, and can vary depending on who's been acting for the developer. So it's not right to think you can look at a lease and every lease will have at clause 4, for example, details about ownership of the relevant title, or at clause 11, details of easements that are being granted to the buyer leaseholder from the landlord. The prescribed clauses have set clause numbers with set information contained within them. So if I'm a Land Registry officer and I want to know whether there are any easements that the landlord is granting with regard to this lease, I can look at prescribed clause 11 and see if there are easements. And then if there are easements, I can deal with them. I would deal with them by registering them against the relevant servient title where appropriate. So prescribed clauses are to an extent an administrative aid for the landlord, for the Land Registry, and for HMRC. When you're acting for a developer, you will draft the lease and make sure the prescribed clauses contain all the information that is needed and that the lease and prescribed clauses are consistent with one another. If you're acting for a buyer, you would check the lease and the prescribed clauses for consistency, as I've just mentioned, and you'd also check that the lease contains such provisions that enable your buyer client to do what they want to do with regard to the property and don't prevent your buyer client from doing things that they would like to do. For example, one of the things I'm asked about a lot at the moment is Airbnb letting. The vast majority of residential leases that I have seen would not allow a leaseholder to let the flat, the apartment or property for Airbnb purposes. Why? The lease will normally say the flat must be occupied by a single household or single family. It will normally say that you're not allowed to let the property for business purposes or use the premises for business purposes. And it will also say you're not allowed to do anything in the premises or property that would constitute a nuisance, either to the landlord or indeed anyone else. Well, Airbnb letting potentially will fall foul of all of those covenants, creating a huge problem and potentially meaning that a landlord could take enforcement action against any leaseholder or tenant that breached those covenants. So I always say to buyer clients and anyone advising a buyer client, you can't let the property that you're buying for Airbnb purposes. The prescribed clauses will normally contain alienation covenants, details of other covenants that prevent it.